Let me tell you the most common responses from the prosecution when you are filing post-conviction. 99.9% of the times when you file a motion for post-conviction relief or a federal writ of habeas corpus to challenge your state level conviction or even your federal conviction, the prosecution is 99.9% of the time going to respond with a motion to dismiss. The motion to dismiss is going to suggest to the court that you are somehow procedurally barred from raising the issues you are attempting to raise on this post-conviction relief or this federal writ of habeas corpus. And what I mean by that is you have specific time frames for which you are supposed to file certain things after your conviction. So if you're outside of that scope, they're going to challenge that first. Now, let's say that that doesn't apply to you. Well, the next thing they're going to challenge is whether or not the issues you are trying to raise were previously raised on appeal or, state level post-conviction. If you haven't raised these issues that you're trying to raise now, they're going to say that those are defaulted as well. Now, in the event that all of those things don't apply to you, well, what the state is going to say is that you don't have any merit and, therefore it should be dismissed. Now, a way to get around that is something that I always talk about, which is called a gateway claim on the federal level. That is actual innocence and or new information that would prove that had this information been presented, the jury would have likely not found you guilty. So there's a number of different ways to get over a procedural bar and a way to defeat that motion to dismiss. Now, if none of that applies, the state will go ahead and file its answering brief. And they will simply try to argue that the things you are stating are a misapplication of law. But remember, you get the final answer in your reply brief, so you can kind of refute what the state says in their answer. So that's something that you should think about when you have a loved one, or if it's your case and you are filing post-conviction and or federal writ of habeas corpus.